Yeah, just have a seat near the clipboard. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. The case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type of offenses, whereas your misdemeanor cases are normally referred to as petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the charge. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of capital murder, which is the highest felony, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, your case is a misdemeanor offense, so you don't have to worry about the felony punishment. Now, misdemeanors are divided into 3 categories. We'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by a fine that does not exceed $500. Now, the Class C misdemeanors are cases that are handled in the JP court or the justice court or the municipal court, which is the city court. For example, not having a seatbelt, not wearing a seatbelt is a Class C misdemeanor. Speeding is a Class C misdemeanor. Having an expired sticker on your vehicle or expired registration is a Class C misdemeanors. Now, as I mentioned earlier, those cases are normally handled in the city court or the JP court. However, if a person is convicted of the Class C misdemeanor in one of those courts and they decide to appeal their case, then the case comes to the county court at law. And when it comes to the county court at law, the range of punishment is still the same. It's by fine only. Now, as I mentioned earlier, it's because it is by fine only, you cannot get any jail time. However, if you fail to pay the fine, or if your fine was converted to community service and you failed to perform the community service, then the court can issue what is called a capias pro fine. That means it's a warrant for your arrest for you to sit out or satisfy the fine. So you can sit out the fine in jail. You will be credited at $100 per day for every day that you sit in jail on your fine. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to 180 days in the county jail, or a fine from $0 to $2,000, or you could be given both such fine and confinement. Now, the range of punishment for a Class A misdemeanor, which is the highest misdemeanor, is minimum 0 days to maximum 365 days, which is a year in the county jail, or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. The first type of probation is called unadjudicated probation. Unadjudicated probation means that it's a type of probation where you will not have a conviction on your record. And if you successfully complete the probationary period, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what we call a non-disclosure. And what a non-disclosure is, it just means that the court or the state cannot disclose the fact that you were on deferred adjudication to the general public. In essence, your record is sealed to the general public. Now, you notice I use the term general public, and that simply means that the government can have access to your record. So, for example, the police department is part of the government. They can have access to it. So any federal, state, or local governmental agency can have access. But most of the public is the general public. They cannot have access to it because your record will be sealed to the general public. Now, the other type of probation is called adjudicated probation. So we have unadjudicated probation and adjudicated probation. Now, with adjudicated probation, you will have a conviction on your record. However, there's something that is called judicial clemency, whereby the court or the judge can set aside your conviction. So you will no longer have a conviction if the court gives you judicial clemency. And that, in order to qualify, you have to successfully complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged off of the probation. If those three things happen, then the court has a discretion to set aside your conviction. And the case cannot be used against you. Now, if you get a subsequent conviction, that is, if you get another conviction on another case later on, then the case that you received judicial clemency on can be revived, resurrected, or brought back up and used against you. And if you try to get a license with CPS, CPS could deny giving you a license, or if you have a license, they can revoke or suspend your license. Now, as a defendant in a criminal case, you have a right to have an attorney. The first right that I'm going to talk about is your right to have an attorney. Now, on the clipboard that you have before you, there should be a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. That document talks about your right to have an attorney. And it states below the title, Judge's Explanation of Rights to Defendants Without an Attorney, it states that as a defendant in a criminal case, you have three options. That's three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, when that statement is made, you may represent yourself. What it's basically saying is that you may waive your right to an attorney or give up your right to an attorney and represent yourself. Now, if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date from today to give you time to hire an attorney to represent you. If you want an attorney, but you do not have enough money to hire an attorney, you will have to fill out a financial questionnaire. Now, the financial questionnaire is a document on the clipboard that is titled Jefferson County Affidavit of Indigence. It's a 3-page document. You will have to fill out the first page. It has a lot of financial information on that first page, and half of the second page. And then the court or the judge will fill out the bottom half of the second page and the third page. Now, if you decide that you would like to represent yourself, that is, you would like to waive your right to an attorney, you will have an opportunity to talk to one of the assistant criminal district attorneys that are here in court today. We call them prosecutors. You'll have an opportunity to talk to them, but you cannot talk to them unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver is titled, it's a document on the clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. That's the waiver of counsel. I will go over that document with you in a few minutes for those of you who will be waiving your right to an attorney. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive your right to have an attorney, or if you choose to represent yourself, you may change your mind at any time and then request that an attorney be appointed to represent you. Now, at the bottom of the document that is titled Judge's Explanation of Rights to Defendants Without Attorney, you'll see 5 lines to the left below a statement that states defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to ask for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you choose to waive your right to an attorney, which means to give up your right to an attorney, and you desire to represent yourself, then you will place your initials on the fifth line to the left and the name of the attorney. Well, you'll place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled Defendant, and you will date it today's date, June 4th of 2024. Now, for those of you who will be waiving your right to an attorney, you will have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And that document states that I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Now, the term voluntarily means that you are doing this of your own free will. And when the term intelligent means that you know what you're doing. So it says that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 4th day of June of 2024 by County Court of Law number 2 of Jefferson County, Texas, of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that is your choice, then you will place your initials on a line that is titled defendant, and you will date it today's date, June 4th. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. When those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence. They will listen to the arguments, and they will deliberate, and then they will decide whether to find you not guilty or guilty of your offense. You also have a right to waive or give up your right to have a trial by jury. By waiving or giving up your right to have a trial by jury, it means that you will not be having a trial by jury. Now, if you waive or give up your right to have a trial by jury, your case will come before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. Somebody might ask, well, how can it come before the judge by way of a trial if I waive my jury? Well, there's something that's called a bench trial. That is trial by judge only. The judge will be the judge and the jury in your case. Now, you can also waive your right to have a trial or have a bench trial. That is, if you don't want a trial by jury, and if you do not want a trial by the judge, that simply means that you are entering a plea of either guilty or no contest to the charge. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. If you enter a plea of no contest, you're telling the court that you would not be contesting or you would not be fighting the charge. Now, you can also enter a plea of not guilty, which means that you are not guilty of these charges and you want a trial. Now, however, if you waive your right to a jury trial, you waive your right to a bench trial, you're telling the court that you want to enter a plea of guilty or no contest, then the second way the case will come before the judge is by way of an unagreed plea bargain agreement or an agreed plea bargain agreement. So what a plea bargain agreement is, it's an agreement that you and your attorney have worked out with the district attorney's office to settle your case. We call that a plea bargain agreement. If you're unable to work out a plea bargain agreement with the district attorney, we call that an unagreed plea bargain agreement. It simply means that you have not been able to work out an agreement. And so because you have not worked out an agreement and because you want to enter a plea of guilty and no contest, then your case will come before the judge. And the judge will decide what your punishment will be within the range of punishment. So for example, if you have a Class B misdemeanor, the judge has to decide whether or not they can give you 0 days to 180 days in the county jail, whether or not to give you a fine from $0 to $2,000, somewhere in there or in between, or they can give you both fine and confinement, or whether or not to give you either deferred probation or what we call unadjudicated probation or adjudicated probation. So the judge will decide that. Now, the other way that your case, the third way that your case will come before the court is by way of an agreed plea bargain agreement. That is, you and the state or you and your attorney in the state have worked out an agreement to settle your case. Then once it comes before the judge can do one of 2 things. The judge can accept your plea bargain agreement or reject the plea bargain agreement. Now, if the court rejects your plea bargain agreement that you made with the state, then you can just simply tell the judge, well, I'm not going forward. I will take back my plea of guilty and no contest. So for example, let's say you and the state have worked out a plea bargain agreement for you to serve 1 day in jail or just say let's say to pay a fine of $100. And the court, it comes before the court, and the court says, I'm not going to follow the agreement. We say, well, judge, since you're not following the agreement, I take my plea back. That is, I'm not entering the plea of no contest, and I'm not entering the plea of guilty to this charge. You have a right to do that. Now, if the judge does follow the plea bargain agreement, and within 30 days, you decide that you would like to appeal your case, and what an appeal is, you would like a higher court to look at this case because you think that you may have been wrongfully convicted or this court committed an error by convicting you. And so if you want to appeal, you have to get permission from the judge who followed the plea bargain agreement. If the judge gives you permission, then your case is going to leave this court and go upstairs to the Ninth Court of Appeals. They will review your case. They can do one of two things. They can either accept or reject your plea bargain, accept or reject the appeal. In essence, they can grant or deny the appeal. If they grant the appeal, they can simply find you not guilty. Case is over. Or they can send the case back down to this court and order this court to give you a whole new trial. If they reject or deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals, located in Austin, Texas. Now, you would have to file what we call a pro se petition for discretionary review. What that means is, pro se means you're representing yourself. You do not have a lawyer. And you're petitioning the Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. If they grant your petition, they could just simply find you not guilty. Or they could send the case back to the Ninth Court of Appeals, or they could send it back to this court and order this court to give you a whole new trial. Now, if they deny your petition, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. And what witnesses do? They testify. They can testify for you or against you. If you represent yourself, you can ask them questions, or if you have an attorney representing you, your attorney can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. That simply means that you will not be calling witnesses in your case. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case that they have against you. Now, you also have a Fifth Amendment right against self-incrimination. What that means is the state cannot force you to testify in your case. So, for example, if you exercise your Fifth Amendment right against self-incrimination, the state cannot call you to the witness stand to testify, because you have a Fifth Amendment right against self-incrimination. Okay? Now, the other thing is you can waive or give up your right. And if you waive or give up your Fifth Amendment right against self-incrimination, that means that you will be testifying in your case. The other right that you have is a right to have discovery. Discovery means you have a right to see the evidence that the state has and the state will be using against you. We call that discovery. Now, you have a right to see your statements, witness statements, lab reports, police reports. You have a right to look at the video recordings, listen to audio recordings, or any instruments that they have. You have a right to have access to it. Now, you also have a right to waive or give up your right to have discovery, which means that you do not want to have access to the evidence. You have a right to not have access to that. You can waive or give up your right. Now, everyone that's here today for your case, you're here because, one, you've been charged with an offense and you've been arrested, and you're out of jail on bond. You're either out on a cash bond, which means that you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bond, a percentage of the bond to get out of jail. Or you're out of jail on what we call a PR bond, or a personal recognizance bond, which means that you did not pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. So, for example, if you spent 5 days in jail, you and the state have worked out a plea bargain agreement for you to serve 5 days in jail, you will not have to serve any more time in jail. Why? Because you'll be given credit for the time that you've already served. And so, therefore, you'll be given credit for time served. You will not have to serve any more time in jail. Now, however, if you serve 5 days in jail and the state is offering 7 days in jail, that means you would only have to serve 2 days because we'll subtract the 5 days from the 7 days, that leaves 2. Now, every day that you spent in jail can also be used towards your fine and court costs. You receive $100 credit for every day that you spent in jail towards your fine and court costs. So if you spent 5 days in jail, that's $500 that can be used towards your fine and court costs. And so if you spent 5 days in jail, the state is offering fine and court costs of $500. That means you won't have to pay nothing. Why? Because the 5 days that you spent in jail, which is $500, has already paid it off. Now, if they're offering fine and court costs of $700, then that means that you would have to only pay $200 because we will subtract the 500 from the 700 and we get $200 that you would have to pay. Now, you would have to pay it on the day that you dispose of your case. If you cannot pay it on the day that you dispose of your case, no problem, because we can put you on a payment plan. And if we put you on a payment plan, you can pay off in monthly installments until the balance is paid off. Now, even if we put you on a payment plan, if you're unable to pay off the balance because of your financial situation, there's no problem because we could convert your fine and court costs to community service, and you will receive $12.50 that will go towards your fine and court costs for every 1 hour of community service that you perform at a nonprofit organization. So if you work an 8-hour day, 8 hours of community service, is $100 that will go toward your fine and court costs. So in our scenario where you're 2 days, you work 2 8-hour days, that's $200 that will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion for individuals who've never been in trouble before. With that program, they will dismiss your case and you can get it wiped off of your record. Now, in order to qualify for that program, it has to be your first time getting in trouble. You have to have an attorney to help you to fill out the application and submit it to the district attorney's office. And it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. Now, if you qualify, as I mentioned, you get into the program. Once you complete the program, they will dismiss the case. You can get it expunged, erased, wiped off, or deleted from your criminal record. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has another program that is called Veterans Court. With that program, only thing you have to do is be a veteran of any one of the branches of the United States military to get in the program. You get into the program, you complete the program, they will dismiss your case. And once the case is completed, then you can get what is called a non-disclosure, where your record will be sealed to the general public. Now, this court has a program that is called the CSI program, stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office. The program started in March of 2017. And with that program, we have partnerships with various agencies. The program is designed to address the issue of what we call recidivism. And recidivism means people commit crimes over and over. So how do we address it? We address it through our Community Safety Initiative. One of the partnerships that we have with Spindletop. Spindletop has a program where they will do private interviews. They can either do it here in the jury room, or they can do it in their facilities or over the phone, depending on what is convenient for you. They also have the ability to do an assessment. They can develop treatment plans as well, address your any mental health needs that you have. Now, in order to participate in the program, you do not have to be incompetent or insane. You can merely suffer from depression or anxiety or any other host of mental illnesses. And they have the ability to address those mental illnesses that an individual may have. Now, if you have issues with drugs or alcohol, well, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR, OSAR, and that stands for Outreach Screening, Assessment, and Referral. Those are drug and alcohol recovery programs. And with those programs, they will do a screening and assessment, and they can develop a treatment plan, either outpatient and inpatient. They can refer you to a facility or place that will be able to address your drug or alcohol addiction. Now, if you are unemployed, you do not have a job, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center. There's a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of the areas that you select, they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school and you'd like to get your GED, CICE has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free, does not cost you anything but time. And I like to say in this court, we don't just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. So I tell people this all the time. When you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will also make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. We have brochures that we can give to you so that you can apply for any one of the programs that I just spoke of. Now, at this time, we have some individuals from Spindletop who is going to come forward. We have Chris and Deputy Hinton. They're going to come forward and tell you more about the program that Spindletop has to offer. Deputy Hinton and Chris.
Thank you, Your Honor.
You
Morning. My name is Steve Hinton. I'm the mental health supervisor of the state. Here for the sheriff department. I'm working here for Chris. Now, Chris is a qualified mental health specialist. The reason we are both here this morning in this courtroom is because the judge cares about every single person within. The judge has found, and statistics prove that those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you in your particular situation.
So when you're putting on our case, it's like a drug set, right? Typically see anxiety, depression, things that at some point in their lives aren't necessarily easier to process. There's obviously a host of other mental issues that can be some that feel like there's someone who cares about you. What matters is that there's a lot of really great community resources out there that are well funded, but they're not well advertised. So even just finding the name for them can be a bit like jumping. And I know with everything else going on, you get overwhelmed sometimes, so that's why we're here.
So maybe this is your first time to be here in court, maybe it's your 10th time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. We need you to share that need with us so we can see best how to advocate to help you. And Chris is gonna explain exactly how you can do that very privately.
So when everybody came in, you were all handed one of these, right? This is handed to everybody. It doesn't matter if you're here as a defendant, it doesn't matter if you're here to support, it doesn't matter if you need information for yourself or someone you care about. This is built like a baseline type of consent form. The reason it's built this way is so that you know that any information you put on the sheet is protected under state law, the same as your medical information. The only thing that this sheet allows me to do is contact you once in a manner you're choosing, or speak to you privately in the back should you want to. There's a lot of really great resources, right? But sometimes the one that we're missing the most of is support. So if you need information from someone else, or if you need to call me, because this gives me a stressful process. This is not a moment anybody expects to find themselves in. We're here. We know you all work hard for yourselves. You all showed up. You walk in through that door, and I'm pretty sure there are some names called that are not in this room, or not in this room, right? We know that you're here. We know that you work for yourself. We want to be able to match that. If there's something that you need, we want to be able to help. That's literally the only thing we're here to do is help. It doesn't matter what it is. It doesn't matter where you're from. You can be from this area. I can have Jackson County from as far as Oklahoma and the border. If you need something and you're having trouble finding it, or if you just need to talk, we're here. We have no limitations in that way. There's nothing as a giant loophole. And anything we help you find, including us, is either going to be state funded or state funded. We're state funded. We're not trying to have that interest in state funded. We know there's a lot of other stuff going on. We want people to ever live.
So I also have this flyer here that I want to get in everyone's hands before you leave here today. On the back of it, it explains some of the benefits of actually participating. But on the front, it also has a 1-800 number, should you ever find yourself in an unsafe place. You can call that number to help immediately.
So what's important about that is it is the first resource in the beginning. Now, like I said, a lot of people in the important Jefferson County are from nowhere close to here, right? That number is active almost statewide. It doesn't matter where you call it from as long as it's not a dead zone, because there's some places in Texas where no phones work. You call it 6 a.m. on Christmas morning, if you are needing to talk to somebody, that is a crisis line, they will be there. If you need a resource immediately, they will be able to find it. But if you just need to talk or set something up, if you have time, the contact that you'll have from me whenever I reach out to you will be my work number. I will be the only one that sees that or responds to it. If you have something you need to talk about or something you need, and we have the time and space to work on it, let's do it. What matters is that we're here, and that we make sure that you have whatever you need to succeed in your day-to-day lives outside of this, because this is just a moment.
And just shortly, the court is going to go into recess, and when it does, we'll be able to come out there, we'll visit with you, I'll be giving this to everyone, we'll be picking up those documents as well. And we'll answer any questions you have to advocate for you as well. Thank you very much. Thank you, Your Honor.
Wait, thank you, Deputy Hinton. Chris. Okay, ladies and gentlemen, we're gonna go into recess in a few minutes. But before we go into recess, I need to give you some instructions. The information that you have on the clipboard, if you need any assistance with filling out that paperwork, we have our core personnel who's here who will be happy to help you fill out the paperwork. Now, once the paperwork is filled out, we're going to pick that paperwork up. We're going to go over the paperwork, and then we're going to call you up before the bench. We call this the bench, one at a time. And then once we finish here, then we're going to call up the next person. Now, if you need to use the restroom, there are 2 restrooms in the hallway. One restroom is in front of County Court at Law number 3. That's the men's restroom. On the opposite side of the hall is the women's restroom in front of the 172nd District Court. Now, you'll be allowed to use the restroom, go out into the hallways. Please do not leave the courthouse. Now, if you leave the courthouse, and if your name is called and you're not here, your bond can be forfeited. And if your bond is forfeited, a warrant could be issued for your arrest. And if a warrant is issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Now, again, this is going to take us a little time to pick up the paperwork from you. So at this time, we're going to go into recess. And if you need any help, just simply raise your hand, and then the court personnel will come out. We have folks in here who's going to come out and help you. So at this time, the court will be in recess. First case is cause number 24 CCCR 0742. Case is style of state of Texas versus Ethan Cole Cochran. Corcoran. Would you please come forward? Mr. Cochran, is it Corcoran?
Yes, sir.
Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Corcoran?
Yeah.
I'm doing fine. Thanks for asking. Mr. Corcoran, I have before me a document, well, two documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that side of defendant?
Yes, sir.
Are these your initials that's on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Corcoran, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Corcoran, I read your answers. I have a question. Let me see, I'm gonna put this mic on mute. Next case is cause number 24 CCCR 0644. Case is style of state of Texas versus George Robert Maxey. Mr. Maxey, your full name is George Robert Maxey. Mr. Maxey, would you please raise your right hand? Mr. Maxey, do you swear, affirm, and tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Maxey, you may put your hand down. How are you doing, Mr. Maxey? That's good. Mr. Maxey, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes.
Mr. Maxson, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yeah.
I had, took this out of order, let's see. 6-4. Maxey, okay. It's gonna be. Hey, Mr. Maxey, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in your case is Attorney Lori Carrazzo. Attorney Carrazzo will be given information to contact you, and you will be given information to contact her. The court coordinator, who is to my right, she will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Now, please have a seat in that first chair on the wall. Next case is cause number 24 CCCR 0242. Case is style of state of Texas versus Sasha Stanford. Ms. Stanford, your full name is Sasha Stanford? Sanford? Ms. Sanford, would you please raise your right hand? Ms. Sanford, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Sanford? You doing all right? Ms. Sanford, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Ms. Sanford, before you signed and initialed these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Ms. Sanford, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Marvel Provo. Attorney Provo will be given information to contact you, and you will also be given information to contact her. The court coordinator will give you that information. Once she gives you that information, you're free to go, and you have a blessed day, and hopefully you have a safe, a healthy baby.
Yes.
All right. Next case is Style of State of Texas versus Keyshawn. Is that Rashid Dancy? Mr. Dancy? Mr. Dancy, your full name is Keyshawn Rashid Dancy. Mr. Dancy, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Dancy, you may put your hand down. How are you doing, Mr. Dancy? That's good. Mr. Dancy, I have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature? I also have a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to apply for court-appointed attorney? Mr. Dancy, before you signed and initialed these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Dancy, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will give information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go, and you have a blessed day. Please have a seat in that fourth chair on the wall. Next case is cause number 24-CCCR 0684. Case is Style of State of Texas versus Brandon Wise. Mr. Wise, would you please come forward? Oh. Mr. Wise, I was looking at okay, Ms. Wise, would you please raise your right hand? Mr. Wise, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yeah. Mr. Wise, you may put your hand down. Now, Mr. Wise, I was looking at, I'm going on mute. Looking Okay, the next case is cause number M330794. The case is styled in the state of Texas versus Chantel Nicole Jacobs. Ms. Jacobs, your full name is Chantel Nicole Jacobs. How you doing, Ms. Jacobs? I'm doing fine, thanks for asking, Ms. Jacobs. Would you please raise your right hand, Ms. Jacobs? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Jacobs, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document before me that is titled Jefferson County Affidavit of Interest. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Ms. Jacobs, before you sign and initial these documents, did you read the documents? You done the same what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Jacobs, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will be giving information to contact you, and you will also be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that first chair. Thank you. Oh, that's right. That's the gentleman. Okay. Next case is cause number 23CCCR 1334, case of South State of Texas versus Marquis Briscoe. Mr. Briscoe, your full name is Marquis Jamon Briscoe?
Yes, sir.
Mr. Briscoe, would you please raise your right hand? Mr. Briscoe, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Briscoe, you may put your hand down. How are you doing, Mr. Briscoe? I'm doing fine, thanks for asking, Mr. Briscoe. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line as titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document before me that is titled Waiver Counsel for purposes of entering guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line as titled Defendant?
Yes, sir.
Mr. Briscoe, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Briscoe, just have a seat, and one of the prosecutors will come out and talk to you about your case. Next case is cause number 24CCCR 0740, case of Style of the State of Texas versus Alberto Caballero. Mr. Caballero, your full name is Alberto Caballero? Oh, excuse me. It says Albert, they have Alberto on here. Alberto. Now, you pronounce that Albert? Who built this? Oh, wow. So they have him as a AKA Alberto Caballero. Okay, now, Mr. Caballero, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Caballero, you may put your hand down. How are you doing, Mr. Caballero?
Yeah.
I'm doing fine, thanks for asking. Mr. Caballero, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line inside of defendant? And all these your initials on the line that state you'd like to waive your right to attorney and represent yourself. I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document? Is this your signature on the line that's titled Defendant? Mr. Cavallaro, before you sign and initial these documents, did you read the documents? You understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Cavallaro, I read your answers. Based on your answers, you would like to apply for, you would like to waive your right to an attorney and represent yourself. Is that correct? All right. Now, you can have a seat, and one of the prosecutors is going to come out and talk to you about your case. Do we have, did we get the paperwork? Wise. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Well, let me do this. Let me swear you in again. Would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay. Now, Mr. Wise, you recognize this document? This document titled Judge's Explanation of Rights to Defendants Without Attorney. Is this your signature on the line that's titled Defendant? You have to speak up.
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Judge's Explanation of Rights to Defendant. Well, that's titled Jefferson County Affidavit of Indigence. I think you need to make this is a document you're going to make a correction on. We talked about that document. We talked about whether or not you received or if you have to pay child support. Is that correct?
Yes, sir.
Okay. He's gonna have to scratch through that,
Okay.
and then he has to put that over here.
Okay.
I know I'm working with him. I didn't total it. We got the same thing at the bottom. So that's 400. His totals all messed up. 1, 2. 50. This is 800. Okay, what I did, I just totaled you the amounts that you had on each side. I put my initials. All right. Now, Mr. Wise, I'm sure your document that's titled Jefferson County Affidavit of Interest, recognize this document. On page 2 of this same document, there's a signature above the line that is titled Defender Signature. Is this your signature?
Yes, sir.
Now, Mr. Wise, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge? Mr. Wise, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you. You will also be given information to contact him. That information will be given to the bailiff. Once you get the information from the bailiff, you can follow the bailiff. You have a blessed day now, Mr. Wise. When you get over to the jail, if you're going to bond out today, you can have your people, the bondsman, or someone contact the magistrate, and the magistrate will set a bond for you at the jail. Now, if you, he's the judge over there at the jail. Now, if you don't do that today, you're gonna be in jail overnight. Okay? Because he'll come back in the morning, and then you'll be arraigned again in the morning. Okay? Just just follow that bailiff.
I'm about to give you this reset.
Next case is cause number 24CCCR 0894, case of Style State of Texas versus Kayla Wiggins. Ms. Wiggins, will you please come back up? And so, Ms. Wiggins, earlier you were sworn in, and you made a correction on your affidavit of indigence. Is that correct?
Yes, sir.
And is everything on these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Ms. Wiggins, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you. You will also be given information to contact him. The court coordinator will give that information to you. Once you get the information, you'll be free to go. Now, before you leave, we need to give you some bond conditions. The bailiff is going to hand you some bond conditions, and I need to go over these bond conditions with you. And the bond conditions states as follows. The title is Jefferson County Bond Conditions and County Court at Law number 2. You see that title? You see that title? Okay, I'm going to go over these bond conditions with you. And it reads as follows. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and a test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Oh, yes, but I mean, I don't have any details on the court and I don't know who the victim is. I don't even know the situation and no one's been communicating with me about that, so.
Okay, hold on a minute. This is an assault bodily injury case. Wow, that allegedly occurred on December 29th. That's 2 days before New Year's, or 3 days before New Year's of 2023. Okay, I would imagine you was arrested on that day.
No,
You wasn't arrested
I
on that
wasn't
day?
arrested until like, I believe last month.
Last month?
I didn't
Okay.
even know anything.
Okay,
about
let me do this here. I have a probable cause affidavit. Do you have that probable cause affidavit that we can look up? And now,
I don't know.
let me do this here. Now, I must advise you that you have a right to remain silent. Anything that you say can and will be used against you in a court of law. So I'm gonna just read to you. I'm gonna let you read the affidavit. So I can read it to you. And then, okay, so let's see. I'll just summarize. It said on December 29, 2023, at about 2 a.m. at 3280 Central Ball Drive, Port to Texas, Jefferson County. The accused Killer Wiggins did then and there committed offense by intentionally and knowingly assault and causing bodily and pain to the complainant. And it says again on December 29, 2023, at approximately 2 a.m., the complainant, Kanisha Lewis, was asked to come outside by a mutual friend, alleging her boyfriend was on the phone and wanted to speak with her. Offense. Once outside, Lewis was assaulted by Keller Williams and the 2 other unknown females. Assault caused Lewis pain and injury. The offense occurred in Port Arthur, Texas, Jefferson County. So that's the incident. Okay. So the person you cannot have any contact with is Kanisha Lewis. Okay. Now I'll just read to you that third condition again. The defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 doesn't apply because it only applies in the DWI case. Your case is not a DWI case. Condition number 5 does apply, and it states defendant is prohibited from possessing a firearm or ammunition. unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that? Okay. Now, Ms. Wiggins, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay, Ms. Wiggins, you have a copy of those bond conditions for your record. You can keep that. You're gonna have a seat in the first chair and wait for your name to be called. Javante Savoy. Mr. Savoy, your full name is Javante Savoy?
Yes, sir.
Savoy, would you please raise your right hand? Savoy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Savoy, you may put your hand down. How are you doing, Mr. Savoy? I'm doing fine, thanks for asking. Now, Mr. Savoy, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Savoy, before you sign and initial these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Sir.
Is everything in these documents true and correct to the best of your knowledge? Okay. Okay, now, Mr. Sawyer, I was looking at your, I was looking at your you that information, I need to give you some bond conditions. The bailiff is gonna hand your documents. Title Standard Bond Conditions in County Court at Law number 2. Do you see that title? And I'm going to go over these bond conditions with you, and it states as follows. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, 1, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 and 4 does not apply. However, condition number 5 does apply. And it states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Okay, I noticed that when I read that condition to you, you started laughing, you started smiling.
No, I was living.
Okay, I know you was looking, but apparently something on there that I read to you caused you to at least smile or think it was funny.
No, sir.
Okay, now I'm gonna tell you this here. If you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest, and you'll be placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay. Now, let me do this here. I'm gonna go off. Could you stand right there? Right here. Right here. Jefferson County Court at Law number 2 is not in session. Court is in session in cause number 23 CCCR 1334. Case is style of state of Texas versus Marquis Jamon Briscoe. Mr. Briscoe, would you please raise your right hand? Mr. Briscoe, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Briscoe, you may put your hand down. How are you doing, Mr. Briscoe? I'm doing fine, thanks for asking. Now, Mr. Briscoe, you have a right to have a record made in this case. Do you waive your record?
Yes, sir.
You waive it?
Yes, sir.
Okay, and the state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, doing yourself.
I'm doing fine, thanks for asking. Mr. Briscoe, I have before me on my computer a document that is titled information sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Marquis Jamon Briscoe, on or about March 10th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of filling a drug test with a falsification device. Do you understand what you've been charged with? And to this charge, how do you plead guilty? Not guilty or no contest?
No contest.
No contest? Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to contest or fight the charges?
Yes, sir.
Mr. Briscoe, I also have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit number 1. Do you recognize this document? On page 2 of this same document, there are 2 sets of initials on the page 2 of this document. The first set of initials is on the line next to the box that's checked nola contendere, which means no contest. Did you place your initials MB on this document?
Yes, sir.
The second set of initials is below a paragraph that is titled Discovery Admonishment, and is next to a statement that reads, I do not request discovery of the evidence. I waive my right to request discovery in the case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal. Do you understand that statement? I also have a document before me that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line next to a statement that states that you like to waive your right to an attorney and represent yourself?
Yes, sir.
And I also have a document that is titled Waiver of Counsel for purposes of entering guilty plea or proceeding to trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Briscoe, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Briscoe, are you a citizen of the United States?
Yes, sir.
Stay over stage 1.
Now, Mr. Briscoe, the state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is the first document that you acknowledge that have your initials on the 2 locations on page 2 and your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection. State's Exhibit number 1 will be admitted. Mr. Briscoe, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Mr. Briscoe, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
For defendant's plea of no contest in light of the time that he spent in Liberty County, the offer from the state is 4 days time served. The court calls tax retired in this case.
Okay, so you spent some time in Liberty County Jail during the pendency of this case?
Yes, sir.
Okay. Now, Mr. Briscoe,
Yes, sir.
the state is offering that you serve 4 days in jail. However, you will not have to serve any more time in the Jefferson County Jail on this case because you've already served in excess of 4 days in jail. Therefore, you'll be given credit for the time that you've already served. court costs in this case will be taxed and retired. That simply means that the time that you spent in jail have already paid off the court costs, so therefore the court costs will be taxed and retired. Mr. Briscoe, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Briscoe, I'll follow the plea bargaining agreement that you've entered into with the state. Mr. Briscoe, this will conclude your case. You're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day. You're welcome.
I think the other one.
Okay, that's Mr. Carter.
And then it's gonna be beyond eight too.
Carver. Caballero.
What? The whole thing?
Just the first, the one I have on site. Give him that.
I'm acting like everybody else today, slow.
Okay, now, Mr. Caballero. I'm pronouncing your last name right? Caballero? Yeah, yeah.
Caballero?
Yeah, make sure it's.
Caballero?
Roll your R's, Judge.
I didn't take Spanish, I took French. I didn't take Spanish, I took French. I was from Louisiana, so. That's what was mandatory over there. Oh, man, that Caballero. That's right?
Yeah, we gonna
Okay.
get it.
Yeah, Caballero. Okay. All right, Mr. Caballero. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing? I'm doing fine, thanks for asking. Now, Mr. Caballero, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office, and the state is represented in this case by Attorney Haley Simmons. Ms. Simmons, how are you doing?
I'm good.
I'm doing fine, thanks for asking. In this information, it says that Alberto Caballero, on or about February 19th, 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Caballero, do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
No contest? Okay. Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Okay. Now, Mr. Caballero, I have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit Number 1. Do you recognize this document? I just wrote on there. On page 2 of this same document, there are 2 sets of initials. The first set of initials is below a paragraph that is titled waiver, and it is on a line next to a box that's checked Nola Contendere. You should place your initials AC on this document.
Yes.
The second set of initials is below a paragraph that is titled Discovery Admonishment, and it is on a line next to a statement that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. You place your initials on this location, at this location, okay? On page 3 of the same document, there is a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have another document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Right here. And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself? I also have another document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Mr. Cavaliero, before you sign and initial these documents, all these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes.
State, I have before me state's exhibit number 1. State, would you like to offer state's one? Okay, Mr. Caballero, I have before me a document. This first document that I showed you. The misdemeanor plea admonishment. The state would like to, this is the same document that have your initials in these 2 locations and your signature on page 3 at the top. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case? Okay. No objection. State's exhibit number 1 will be admitted. Now, Mr. Caballero, is there any evidence that you are currently mentally incompetent to stand trial? Okay, just no evidence of that. Okay. Now, Mr. Caballero, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Now, I forgot to mention to you that you have a right to have a court reporter to type down everything that's being said. And you also have a right to waive or give up your right to have a court reporter to type down everything that's being said. Do you waive or give up your right to have a court reporter?
Yes, sir.
Okay. Now, Mr. Caballero, again, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what's the agreement?
In exchange for a defendant's plea of no contest, the state's offering 1 year deferred probation, $500 fine, 60 hours community service plus court cost.
What is the court cost in this case?
277.
Okay. Mr. Caballero, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500. You will also be required to pay a court cost of $277. You'll be required to pay probation fee of $6 a month, a year analysis fee of $15 a month, and a reimbursement fee of $15. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $154 a month. Will you be able to pay the $154 a month? Just let me, if you can't, just yes or no. If you can't, that's fine. We can do something else. If you can,
I don't work.
okay, good. Okay. Do we have that's all I need to know. Okay. Do we have an affidavit of indigence? No, I'm saying they may have had one when he was in jail. When you got arrested, they may have filled one out. When you got arraigned, I don't know, how long did you stay in jail?
All right.
How long did you stay in jail? When you got arrested, did you get out?
I got one.
Oh, we have one? Okay. Okay, no problem. Now, this doesn't affect uh the your plea bargain in a way where the judge can accept or reject it. It doesn't affect it in that way. Okay. It's just that I have to look at that. And then there's some other things we can do. The law allows us to do other things. I think I explained it to y'all during the arraignment. Yeah, okay. Okay, here we go. I guess at one time you were working. Okay. Ms. Bailey,
Yes, sir.
would you please hand this here to Mr. Caballero? The bailiff is handing you a document that is titled Affidavit of Injuries. Would you review that document? He doesn't have to fill nothing. That's supposed to fill out at the jail. Would you please hand that document to, now, Mr. Caballero, do you recognize that document? That was a document that was filled out at the jail. Okay, on page 2 of that document, on the top right hand, at the top left-hand side, there's a signature above the line that is titled Defender Signature. Is that your signature?
Yes.
Now, Mr. Caballero, after reviewing that document, is everything in that document still true and correct today or not? Because I noticed that two things. One, you stated that you're not working. On that affidavit, when you were arrested, you probably was working. You were working. I mean, now, okay, so let me see that document. So other than that, is everything, whole document,
Oh, you want the,
document.
you want the documents?
So, okay, now, Mr. Caballero, you're currently unemployed, is that correct?
Yes, sir.
All right. Now, Mr. Caballero, the court is going to find that you're indigent based on the finding of indigency. See, he's indigent. It's 42.1. The fine of $500 plus court costs of $277 is going to be converted to community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. Let's see, that's 777. And that's it's gonna be 62 hours of community service. The probation fee, $60 a month, is gonna be reduced to the statutory minimum of $25 a month, excuse me. $25 a month times. Okay. Okay. So that's 300 plus 8 plus 15 equals. Okay. So your probation fee, well, let me Okay. Now, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you're required to pay a fine of $500 plus court costs of $277, which comes to a total of fine and court costs of $777. The $777 fine and court costs will be converted to 62 hours of community service. And the probation fee of $60 a month will be reduced to the statutory minimum of $25 a month. You'll also be required to pay a year announcement fee of $15 a month, or a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $45 a month. Are you able to pay the $45 a month? Okay. Now, the 62 hours of community service that was converted from the fine and court costs will be in addition to the 60 hours of community service that you're required to do. And that comes to a total of 122 hours of community service. Do you understand that? All right. And you will also be required to adhere to the other standard terms and conditions of this probation. Mr. Caballero, do you understand the state's offer? And do you think that the state's offer in your case is fair? And yes. And do you accept the state's offer?
Yes.
Okay, Mr. Caballero, I will accept the plea bargain agreement that you have entered into with the state. Now, Mr. Caballero, if you successfully complete this probation, your case will be dismissed. It would not result in a conviction on your record, and you may qualify for non-disclosure. And once you complete this probation, you can talk to an attorney about a non-disclosure. All right. Now, you're going to stand and just have a seat. And then, because we had to make some adjustments on the judgment, she's going to make those adjustments. Once you make those adjustments, she's going to call you up to the window. You're going to follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go. And who is that young lady right there? That's your mom? Okay, so you have a support system. Thank God you have a mom that's here who is supporting you. And I know you heard what I told the other gentleman. You know, some people don't have a mom. You have a mom, and she's here right now. And so that young lady right there have your back. Okay. And just continue to do what your mom, your parents is telling you to do, and you'll be all right. And you can put this all behind you. Okay, because your case can get dismissed, you can get it a non-disclosure. All right. And you have a blessed day. Just have a seat. And ma'am, nice seeing you. Thanks for coming out to support your son. Oh, she doesn't? Okay.
She understands.
Okay. See,
Oh, he waved and she waved back.
Jefferson County Court at Law number 2 is back in session. Court is in session and calls number 24-CCCR 0708. Case in style of the state of Texas versus Anthony Joseph Harmon. Anthony Joseph Harmon was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Anthony Harmon at the courthouse door. Anthony Harmon did not answer. Anthony Harmon has not appeared in court since the court has been in session. The time now is 12:58 p.m. on today's date of June 4th of 2024. Ms. Bailiff, would you please call the name of Anthony Harmon at the courthouse door?
Yes, sir. Anthony Harmon. Anthony Harmon. There's my son.
Anthony Harmon's name was just called at the courthouse door. Anthony Harmon did not answer. A reasonable time has passed to give Mr. Harmon an opportunity to appear in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Anthony Harmon's bond will be forfeited. A warrant shall be issued for his arrest. And cause number 24-CCCR 0708. And this will conclude the calling of the court's arraignment docket. On today's date of on the day's date of June 4th, 2024, in County Court at Law number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.